Yes, sir. You are audible, sir.
Yeah, all right.
Okay, so I am starting this session. I am Dr. Rajesh Singh from Parul University, Associate Professor, Parul Institute of Law, Parul University, Waghodia, Vadodara. A warm welcome with one of the greatest advocate from Supreme Court, S.N. Bhatt, who has a wide practice of 30 years, and he has looked after various matters in Supreme Court regarding the civil matters as well as criminal and the service matters. He has a certain reportable judgment. I am just quoting 2-3 judgments, which is a reportable judgment in the Supreme Court in H.N. Jagannath versus State of Karnataka, Bin Nagji Rao versus the Special Land Acquisition Officer, R.R. Inamdar versus State of Karnataka. So there are various reportable judgment with sir, and he has a very wide experience. Today he will elaborate the student of Parul Institute of Law as well as the legal fraternity of Gujarat. So, and all over India also the people are going to listen you, sir. And we have a great pleasure that you have approached. I will just request our Dean Akhil Sayyed sir to give a warm welcome to S.N. Bhatt sir. Akhil sir. Hello, Akhil sir. Hello, Brijesh sir. Hello. Sir, your voice is not coming, Akhil sir. Hello, Akhil sir. Hello. Hello, Brijesh sir. Hello.
Hello. Hello.
Hello. Yes, sir.
Yes. Rajesh sir, you only start. Akhil sir's voice is not clear, and we are live.
Okay. So the topic. So today's topic is the principle of force majeure and its possible impact in the present circumstances. I warm welcome S.N. Bhatt sir, who is the senior advocate at Supreme Court, and he is currently live from Parul University, and we have a great pleasure, and we are very much thankful that sir has given us a time of half an hour because of his tight schedule. So please, sir, I am handing over to S.N. Bhatt sir. Handing over to you, sir, S.N. Bhatt sir.
Oh, thank you. Thank you, Rajesh ji. Thank you very much. Thank you for your warm welcome. I'm really glad to meet you people at least virtually. These days it is impossible to meet person to person. Circumstances are such that we are constrained. But this virtual meeting that you have arranged, I am really glad that, at least some kind of exchange of views we can possibly have over the internet because of the technological development. Unfortunately, this is such that almost everybody in the world, the entire global population has been affected by this unprecedented, unheard of crisis the human kind has been presented with by nature. The present crisis is one that nobody would have ever dreamt of. It's worse than World War I or World War II. We almost none of us were there during the time of World War II. Here, about the difficulties faced by the mankind during World War II was that it was almost crunching kind of time to everybody all over the world at that time. It affected everybody at that time, it appears. Today, the things are much worse in the sense that it has affected almost every living being in every nook and corner of the world. The effect of this unprecedented pandemic would have its own repercussions on human relationships and inevitably on legal relationships as well. So naturally, the question that would arise among the legal fraternity, among students of law, those who are interested in law, is that what would be the possible impact of the present circumstances on the contractual relationship between parties, contracts which have been entered into in various spheres, because contract is one such thing that pervades almost all relationships, legal relationship among people, be it employer-employee, be it commercial contracts, be it service contracts, be it landlord and tenant or lesser and lessee relationship. It has its own impact on almost all relationships. So a major topic about the possible repercussions of the present in the present scenario is what would be the repercussions on the contractual relationships among people or legal entities. The uppermost thing that comes into mind is the principle of force majeure in this regard. As far as the principle of force majeure is concerned, in India, the statutory provisions with regard to that are governed by sections 32 and section 56 of the Indian Contract Act. As you're all aware, as the students of law and persons interested in legal studies, Indian Contract Act is basically founded on the common law principles of contract. Common law principles of contract, as administered in England, developed over centuries, basically by the British courts. In resolving disputes that came before the courts on a case-to-case basis. Because in England, during those days, there was no codified law of contract. It was basically evolved by the courts, by the common law courts. Whenever disputes with regard to contractual relationship or contract touching upon contracts came before the courts evolved principles from one case to the other. The thread went on developing, one precedent being quoted in the next case, etc., etc. As new cases came up, new principles to meet the new challenge or new problem presented by that case. Legal principles evolved in England, which was the foundation of common law contract. Now, the fundamental principle in English law, as it was being administered in the initial years, was with regard to the respect to the sanctity of contract. Because contract or a commitment made by the parties who have solemnly entered into agreement to perform certain things should be obliged to perform it come what may, because they should not be allowed. So that was the basic principle on which initially the courts insisted upon. But as times passed by, cases came before the courts which presented new difficulties, in the sense that the parties who had got into contractual relationships, who had entered into agreements, though at that time they did not foresee certain difficulties, later, when the time for performance of the contract came, certain difficulties which were not foreseen beyond the control of the parties came about, and the courts were asked to resolve this difficulty by the defendant who was asked to perform his part of the contract, or to pay damages for his inability to perform the contract. In those kind of cases where the party who was in unforeseen difficulty in performing his part of the contract, which neither of the parties had foreseen at the time of entering the contract, the court tried to in order to relieve the genuine difficulty of the party who could not, in fairness, have been forced to abide by the contract. So, in these cases, in order to relieve the parties, and the principle of force majeure, meaning thereby the principle that parties could be relieved of their obligations to perform the contract, where certain intervening difficulties, unforeseen and beyond the control of the parties, had taken place, meaning thereby a principle of force majeure had come into effect. Those kind of cases, the courts really relieve the parties. Now, in order to found certain principles on which this force majeure had to be, principle of force majeure had to be founded, the courts rationalized, because the founding principle of all contractual relationship was that sanctity of the contract has to be respected. You cannot really say that I cannot perform what I have promised. So there is a founding principle. The courts then evolved a principle to relieve the parties, in which they found, because of the great difficulty of intervening unforeseen, beyond the unforeseen circumstances, beyond the control of the parties. The court said that this principle of force majeure is inbuilt or implicit in the terms of the contract between the parties. So we are not writing anything new. We are not rewriting the contract. This is something new, that nothing new is being introduced by us. Basically, we are only saying that the parties actually, at the time of entering into the contract, had contemplated as between themselves that in the event of impossibility, the parties would be relieved of performing their contract. This is one of the theories on which principle of force majeure was evolved by the courts. Later on, some other rationalization of this principle was also developed by the courts. They said that it is not implicit in the contract, but then we are looking at the contract as a reasonable man would interpret it. Whether a reasonable man would insist upon performance of a contract which has become impossible of performance because of the supervening circumstances. As far as India is concerned, in India, the law with regard to contract and contractual relationships is basically governed by Indian Contract Act, as I mentioned at the beginning. Now, the governing provisions are, as I said, Section 32 and Section 56 of the Indian Contract Act. Section 32 of the Indian Contract Act talks about contingent contracts, where the parties say that they contemplate at the beginning, at the time of entering into the contract, that in the event of happening or of a particular uncertain future event, the contract would come into effect or would not come into effect, would not be performed. So, as far as Section 32 is concerned, the parties themselves would have foreseen a particular event happening in the future, and only in the event of that event happening or not happening, the parties' obligations would fructify or would not fructify. So it is, as far as Section a contract in which the parties have already foreseen the happening of a particular incident, then only the contractual relationship come into effect. But Section 56 says that even where the contract has been solemnly entered into between the parties, the parties may be relieved of performance at the time of the time comes for performance of the contract. The event to perform the contract, or it becomes unlawful because of certain governmental actions or edicts. The provisions of Section 32 and Section 56 of the Indian contract have been subject matter of interpretation and application to cases in India over a long period of time. And the most authoritative judgment, which is a landmark judgment in India, is that of the Supreme Court in the year 1954. That is in Satyabrata Ghosh's case. That is a very important case, and the facts of the case are very interesting. I would like to have a discussion in a fairly little detail, particularly the facts of that case, so that one could understand the ratio of the case. Because as students of law, you would very well know that unless one goes into the facts of the case in detail, it is impossible to understand what the court has said, what is the law laid down by the court, or what is the ratio of the case, or what is the principle applied in the case, or what emerges from the case. The facts of the case, before going into the facts of the case, I would like to, now that most of them, you are students of law, I would like to tell you one thing. Your professors and your lecturers would have told you this over and over again, but it bears, as a practitioner, I have experienced it, it bears repetition, and that is the reason why I take this opportunity to tell you this. It is very, very important for legal professionals. You would be getting into legal profession in times to come. It is very important for a lawyer to know the facts of his case as thoroughly as possible. As a lawyer, try to read and reread your brief and do not consider any detail of the case as unimportant. There is no detail in the case from the cause title to the judge who has written the judgment that is unimportant to an advocate who is going to take up a brief on behalf of a client. Every little detail, every little fact, every little data concerning and every little detail with regard to the personalities involved in the case is important from the point of view of a lawyer. I remember reading about a very leading and successful lawyer who was a criminal lawyer in the United States of America. He had the highest ratio of success in defending criminal in criminal cases accused persons. It was said of him that he used to visit the crime scene immediately after he was engaged, even before the preliminary facts of the case he would become aware of the preliminary facts of the case. And during the course of the trial, he would make it a point as the evidence would unfold from the prosecution case, repeatedly go to the scene of occurrence in order to appreciate what is being laid out by way of evidence and in order to pick holes in the prosecution case. This was his usual practice. He would be as thorough with the facts of the case as possible. Therefore, it is very important from the point of view of a lawyer to go into the facts of the case, and whenever you read any decision, kindly make it a point to read the facts of the case and digest the facts of the case first and then try to read the judgment and the principles applied therein. Because divorced from the facts of the case, there is no decision of the court which would make any sense at all. Now, coming back to, after this little aside, coming back to Satyabrata. Rajesh, I am audible? Hello? Hello? Hello?
Yes, sir, you are audible, sir.
Yeah. Coming back to Satyabrata Ghosh's case, in which the great Supreme Court Judge Justice B.K. Mukherjee had laid down the judgment. The facts were a land developer was developing a certain piece of land for residential layout near Calcutta. This was in 1940s. He had made certain carved out certain plots, and he was supposed to give certain amenities in the residential layout, form roads, give water connection, etc., and hand over possession to the intending purchasers. One of the intending purchasers gave an advance amount to him and entered into an agreement to purchase one plot of land from him after completion of the layout. In the meanwhile, after the agreement was entered into, in the meanwhile, because of the Second World War, the government requisitioned this particular piece of land for war purposes and took possession of the land. Because of the requisition and taking over possession of the land by the government, the land developer could not complete the project in time. He therefore sent a notice to the intending purchaser saying that, look here, government has taken over possession of the land. I cannot possibly complete this project. Therefore, you take back the amount that you have paid by way of advance. Or in the alternative, you take the land as it is after paying the balance amount. Or even as a third alternative, if you are not willing to do either of the two, uh, the amount that you have paid would be forfeited, and I would be relieved of performing my part of the contract because of the intervening event that has happened in the shape of requisition and taking over possession of the property by the government. The intending purchaser did not want any one of these options. One option was worse than the other as far as he was concerned. So he refused to take either of the options offered to him in lieu of performance of the contract. Therefore, he approached the court and prayed for a decree against the developer for performance of the contract and to complete the project and hand over possession of the property as originally agreed upon by the parties. Now, the defense of the developer in the case was that the requisition of the property and taking over possession of the property of the government was an event which relieved him of performance of his contract, and therefore there cannot be any action against him for performance of contract. The Supreme Court, after the decree was made by the trial court, ultimately upheld it. The Supreme Court said that as far as India is concerned, only Section 56 governs the issue of force majeure. There is no other provision which or principle of law which would come to the aid of person who seeks to avoid a contract on the basis of force majeure. The law of frustration is embodied in Section 56 of the Contract Act, and we have only to look at Section 56 and what is stated therein for the purpose of finding out whether a contract has been rendered impossible of performance or its performance has become illegal or unlawful. There is no other principle that we can possibly invoke. The second principle that Supreme Court laid down in that case was, you cannot go to the general principles of frustration as evolved by the English courts in common law body for the purpose of looking into Indian contracts. The Supreme Court also said that when Section 56 speaks of impossibility of contract, it doesn't merely mean only physical impossibility of the contract, but even contracts which performance of which would be practically would become impractical, in the sense that it would be one would not be performing what was basically originally agreed upon by the parties, but something totally different, which is fundamentally the circumstances have changed so much by the events in between that one is performing something totally different from what was agreed upon. In that event also, the contract would be frustrated and the party would be relieved of his obligations. Most importantly, the Supreme Court also said mere difficulties or onerousness on the part of one of the parties in performing the contract would not relieve a party under Section 56. It also said that importantly in that particular case, which clinched the issue as far as that case was concerned in favor of the plaintiff, the intending purchaser, was that the requisition made by the government was, and taking over possession by the government was of a temporary nature. It was not a permanent acquisition of the land by the government. Only for the period of war, the government has taken possession of the property, and in due time, the government would be giving back the possession of the property to the landowner. And again, importantly, the agreement between the parties did not specify any time limit for the performance of the contract, meaning thereby the landowner, land developer could, after taking back possession from the government, complete the project and hand over the plot of land as originally agreed upon to the intending purchaser. So, therefore, the fact that there was a temporary impediment in the way of the developer, and the fact that there was no time limit specified by the parties for performance of the contract would show that Section 56 has no role to play in the case. Pertinently, the Supreme Court said that if the parties had specified any time limit, and it would not have been possible for the land developer to complete it within that time limit because of the requisition made by the government, it would have been a different matter. So the yardstick that applied by the Supreme Court is important because the court said that it is temporary nature of the difficulties faced by the developer that negatives his contention as qua Section 56. So the important thing, the important takeaway from the case is, as far as the principles of law is concerned, firstly, Section 56, coupled with Section 32, of course, of the Contract Act govern the field as far as India is concerned, and the general principles of English law or common law would not be applicable here in India. As far as force majeure is concerned. Secondly, it is not, when the provision speaks of impossibility of performance, it is not physical impossibility alone, but even difficulties which would fundamentally and drastically change the relationship between the parties would also come into play. But mere difficulty of a temporary nature or onerousness of the obligation, as it turns out because of the events, this case, Satyaprakash Ghosh's case, has been followed time and time again in India by various judgments of the Supreme Court itself, where, in Alopi Prasad's case in 1960, one of the parties which was supplying ghee, the ghee case, to the Union of India, to the army, said that the procurement has become exorbitantly expensive, so I should be relieved. The court said that merely because of the price rise or anything of the sort, you cannot be relieved of that. Again, recently in Energy Watchdog's case in 2017, also Supreme Court followed the decision of Satyaprakash Ghosh's case, where electricity company said that the supply of generation of electricity at the originally agreed rate would be prohibitively expensive for them because the rise in prices of coal procurement from Indonesia. Again, the Supreme Court said that rise in price of from a source, that is Indonesian source, as far as coal is concerned, would not relieve the party, and he cannot invoke Section 56. And there are other cases also which generally follow the line laid down in the Ghosh case. The upshot of the entire thing, as far as the present situation is concerned, as you would know, that this we hope and we are fairly certain that the present crisis is of a temporary nature, and this present crisis may have certain impact on the financial position, as well as the ability and capacity to perform contract obligations on the parties, quite a few parties. But the question would arise merely because of the restrictions or lockdown that has been imposed by the government for a temporary period, month or two, or merely because the performance of the contract would make it prohibitively expensive for a particular party which had entered into an obligation before the coming into the course of lockdown. Would it attract Section 56? Again, as I see it, it would be dependent mostly on the nature of the transaction that the parties have entered into, the nature of the obligations, mutual obligations, the period within which they undertook to perform, and the host of other factors. Because courts would ultimately, when deciding a case, be making a value judgment. The courts always would make their own decision ultimately on the facts of each case. For example, by way of an illustration, supposing a travel company had undertaken to take a touring party, say in the month of April, from place X to place Y. Now, because of the lockdown and the restrictions imposed on travel and by the government, it was impossible for the travel company to take the touring party, and it was impossible for the touring party also to undertake the journey. In that event, possibly Section 56 would come into play. But supposing the very same travel company had given the tour a particular company or an employees of a particular company to go ferry them from place X to place Y over a period of 2 years for a particular price. Supposing the employees of the company were to be carried from their residence or workplace to the workplace. Supposing the agreement or the contract is for a period of 2 or 3 years. Now the travel agent or the operator, if he turns around and says, "Look here, all my drivers or all my employees have gone away, so I cannot possibly now today, even after the lifting of the lockdown, make them operate the buses," then the things might be different altogether. Because the mere fact that some of the drivers or some of the migrant workers or some of the workforce had left their place of work, and the travel agent or the tour operator finds it difficult or onerous to get alternative source of alternative workforce, may not relieve him of his obligation under Section 56. He might be liable for damages. I am only giving an illustration because the restrictions imposed by the government, the lockdown period operated only for a limited time, in which event he cannot possibly turn around and say that now it has become very difficult for me or more expensive for me. I have to pay double the salary to the drivers because of the lack of drivers or workforce available. He may not. This is only by an illustration that I am trying to highlight the position in law as obtaining in India under Section 56. Of course, there are various directions being given by the government today under the Epidemic Act and Disaster Management Act also. That also might come into play. Those would be for that will be important for analysis of the case when as and when. But there would not be, in my opinion, a uniform and universal application of principle of 56 in all sorts of contracts in the present circumstances. As I was saying earlier, it would depend upon facts of each case and the nature of the obligation and the nature of the contractual terms and the duration of the term, etc., etc. So it will vary from case to case. Now, this is as far as commercial contracts are concerned. Again, as far as employer-employee relationship is concerned in India, as you people would be aware, most of the employer-employee relationship are governed basically by statutory rules and regulations, Industrial Disputes Act, Payment of Wage Act. As far as government companies are concerned, their company regulations, etc., etc. And therefore, the provisions of Section 56 would have very little role to play. Coming to the issue of relationship between lessor and lessee is concerned, again, I want to make an important point here. There was a kind of raging discussion in the media about whether the tenants or the lessees who are taken premises on lease would be relieved of payment of rental amount to the landlord because of the lockdown and non-user of the premises during the period of lockdown. But as far as Transfer of Property Act is concerned, which governs the relationship of lessor and lessee, the provisions of Contract Act do not apply to Transfer of Property Act. Section 4 of Transfer of Property Act specifically says provisions of Transfer of Property Act should be read as supplemental to the Contract Act. But at the same time, provisions of Contract Act are not part of Transfer of Property Act. Once a transfer has taken place and is complete, like in the case of a lease, where the lessor has demised the premises under a lease deed to the lessee, the interest in the property, leasehold interest, stands transferred to the lessee, and the relationship is governed purely under the provisions of Transfer of Property Act. Therefore, by definition, Section 56 of the Contract Act has no application to leasehold relationship where the lease has been executed and the lessee has taken possession of the property under the lease. Meaning that the has become complete. This has been laid down by two important decisions of the Supreme Court. One in Raja Dhrudev's case, that is in the year 1968. And another in Sushila Devi's case, that was in the year 1971. Now, interestingly, in both the cases, the facts are almost similar, though they say that no two cases are identical. But in this case, facts are almost similar. But again, interestingly, the result of both the cases were diametrically opposite to each other. In Raja Dhruvdev's case, a piece of agricultural property in the present day Pakistan was taken on lease by the plaintiff because of communal disturbances immediately before the partition. He could not, the plaintiff lessee could not really cultivate the property and take effective usufructs out of the property. So he could not really work the lease. He had ultimately to leave the property because of communal disturbance. He